Service contracts require you as the service provider to perform work until the project is complete, or else face liability or project and contract termination. So in the wake of wildfire season, especially in the northwestern part of the United States where I live and in Canada, and amidst the busy wedding season during peak wildfire season, which is really kind of end of June, July, August, September, hopefully not too much longer than that and too much before that, but every year it changes. But really summertime up here in the Northwest, and with all of the trees abound, many people in the wedding industry and that are providing services of any kind during this period of time want to understand the impact that an unexpected event such as a wildfire could have on their ability to perform under the contract. So events such as hurricanes, wildfires, floods, all kinds of other natural disasters, they're becoming more common, and they can cause extreme damage to a location to the extent that your performance can be greatly affected. And in this episode, I am going to get into really what needs to be in your force majeure clause, what it is, how to invoke it either as the service provider and the company under the contract, or for a client or clients to invoke it under your contract, what typical force majeure events actually are, why notice is in a force majeure clause, why it's important, what it means, how to follow the notice requirement. Additional language I want to make sure that you have at the end of your force majeure clause. And then, of course, I'm going to answer the question, is a wildfire a force majeure event? So let's get into what is a force majeure clause. A force majeure clause, and I feel like I am this force majeure expert at this point because I have been just regurgitating this over and over again since 2020. I could have never predicted that I was going to think about force majeure clauses and force majeure language so much in my contract attorney career, but here I am. So a force majeure clause is really a way in a contract to deal with the effects of unforeseeable, unpredictable, uncontrollable events that make it impossible to perform. It's a way in a contract to deal with, okay, one party can't perform or both parties can't perform, and this doesn't equal a breach of contract. What does this mean? How do we go about kind of curing performance under this contract? So here's what this clause and provision does in your contract. It removes liability from you as the service provider in the company and for your clients. And it dictates what happens to performance under the contract if that natural catastrophe interrupts the expected kind of project timeline or intended day of services, which would prevent you from fulfilling your contractual obligations under the contract, or for your clients, say they have the contractual obligation to pay and they're not able to do so due to a force majeure event. So Black's Law Dictionary defines quote unquote force majeure as an event or effect that can neither be anticipated or controlled, especially an unexpected event that prevents someone from doing or completing something that they had agreed or officially planned to do. So this term of superior strength, force majeure, in French includes both acts of nature, so floods, hurricanes, wildfires, etc., and acts of people, riots, strikes, wars. And as of spring of 2020, force majeure clauses now even include epidemics and pandemics. So force majeure clauses are really key components of any service-based contract that you are sending to your clients or that you are signing as a business owner if you're in a B2B relationship. And you should make sure that a force majeure clause is included in all of the contracts that you issue to your clients. Now, I want to talk about typical force majeure events. I know I already said, earthquakes, hurricanes, tornadoes, floods, and wildfires. Certain man-made events may also be considered force majeure events. These include kind of civil or military disturbances, terrorism, explosions, strikes, scarcity of energy supplies. Really, truly, a force majeure event needs to be expressly delineated in your force majeure clause. And it needs to say anything that cannot be anticipated, that is unpredictable, unforeseeable, and the factors that would and could impede progress and performance, and how that would be negotiated between the parties on how to cure performance. So I want to bring up here our force majeure clause, and kind of in lay people speak, I am going to walk you through what it says, not in full verbatim legal language, but I'm going to take you through the various components of a force majeure clause. Mind you, I'm looking at this clause right now. It is almost half a page. That seems extreme, but here's the deal. Everybody and their dog knows about force majeure clauses now since 2020. The silver lining here is clients are now looking at force majeure clauses. They're looking at clauses like this with more laser beam focus than ever before. And you as a service provider need to be doing the same. You need this clause in your contract. So if you don't have a Legal Paige contract, please, please, please at least get this a la carte clause, or pull up your existing contract and walk through this with me. Make sure that you have all of these components that I'm talking about in your force majeure clause. And if not, we do have an a la carte clause. I will make sure to link that in the episode description for you, and you can add it to your existing contract. If you have a Legal Paige contract, don't worry, this clause is already in it. So the beginning of the clause really needs to say that no party or either party will not be liable or responsible to the other party, nor be deemed to have defaulted or breached this agreement. That's the big key here, for any failure or delay in fulfilling or performing any term of the agreement when they are impacted by a force majeure event. And then you want to go on and expressly delineate what is a force majeure event. We literally put the language that is beyond the impacted parties' control, that are unforeseen and unpredictable at the time of contracting. That is big here. If you don't have that language in your contract, then they can really say, well, it might have been predictable then, but it wasn't predictable now, or vice versa. At the time of contracting, is this potential situation unforeseeable and unpredictable? Hopefully you're catching my drift here, where I am going to be talking about wildfires. And if you're in a specific region where wildfires are a little bit more foreseeable and predictable, it may not be a force majeure event. And then you want to go on and say, force majeure events they include, but are not limited to, the following. Boom, colon, and then just list them out. Acts of God, natural disasters, put in parens what those are: fires, explosions, hurricanes, floods, wildfires, storms, yada, yada, infestations. We put epidemics and pandemics in there. Wars, invasion, hostilities, government laws or orders, embargoes, blockades, actions by government authorities, national or regional emergencies, strikes, labor stoppages, industrial disturbances, shortages of adequate power or transportation facilities. I'm going to get into a situation here in a second on what happened in my hometown of Missoula, Montana, just a couple of weeks ago regarding adequate power and how that was an actual force majeure event. Okay, so you're going to say all of that at the beginning of your clause. You're going to say, okay, here is where a force majeure event comes into play, what it means for non-breach of contract purposes. And here are, I am expressing and including all of these delineated things as force majeure events. And then you want to say what happens when a party is impacted. This is all about a notice requirement. I will be getting into that in a little bit more depth here, but in the clause, you just really need to explain, okay, the impacted party needs to notify the other party within this period of time, and then they have a certain period of time to cure performance. Usually, that's around 30 days. You could make it shorter or longer. There's no rhyme or reason to this, but usually 30 days is a good period of time in most service contracts. And you just need to think about your specific services that you're offering. If I needed to cure performance due to a force majeure event, how long would be a reasonable period of time? And then if performance is not cured within that time, and of course, it has to be, reasonably practical to be able to perform after the force majeure event. And you have to use your due diligence to try and cure performance. If at all costs you cannot, then you would have to terminate the agreement. And then this is the kicker that wasn't in a lot of contracts at the beginning of 2020, which left people feeling uneasy and not sure what to do, and clients basically asking for refunds in this situation, is what happens with fees paid. So you need to explain at the end of your force majeure clause what happens to retainer payments and all other payments made by the client or clients up to the date of notice of a force majeure event. Are they refundable, transferable, or are they non-refundable? And usually for service-based businesses, I would suggest that they're non-refundable, but if they are terminated due to the impossibility of the person who is impacted for them to cure performance, that any payments made by the client would be like credited to the client's account for a certain period of time, and must be used within that certain period of time. So basically, they're non-refundable payments, but transferable. And so they would be transferable due to only a force majeure event. Usually you're going to have different language in like a voluntary cancellation or rescheduling situation by the client. That's in a different clause in your contract. But here, if a force majeure event is ultimately terminating the contract because you weren't able to cure performance to the best of your abilities, or vice versa, your clients weren't able to cure performance under these notice requirements, then you could terminate, but you would need to use those fees paid that are credited to your client's account within an X period of time. Usually that's a year or two max. I want to get into a little more what is notice and why is it important in a force majeure clause. And honestly, this is becoming more of a controversial topic in contract law, honestly, due to the Maui wildfire in Lahaina and what happened with their inability to really determine if they could cure performance within a certain period of time. As you know, just nobody knew when things were going to get back to normal. And so that was left to then contract negotiations. But notice in a clause like this is all about notifying the other party that there is a force majeure event that has impacted them. And it explains that the impact of a force majeure event cannot last forever. So it just puts a time frame on it. And that's why I like notice requirements in these clauses. So it allows a party to the contract to basically claim force majeure for a certain period of time. Usually, if you are impacted by a force majeure event and you are under contract, and especially in the wedding and event industry when you have thousands of dollars on the line, whoever is impacted or, performance is going to be delayed in some respect due to a force majeure event, they're going to notify the other party right away. But I like to set a time limit on it. That's the first notice requirement in the middle of this clause, usually within 5 to 10 days. If you've been impacted, you need to tell the other party within a reasonable period of time after the force majeure event. If not, as soon as practicable after the force majeure event. Notice often comes into play to protect yourself from any potential litigation. So in a worst case scenario, if your client doesn't like the alternative performances that you propose to respond to the force majeure event, they could potentially bring suit against you. So providing notice to them establishes that record evidence proof that your clients contacted you or you contacted them. That's the notification requirement within the time period set forth in your force majeure clause. And then that you contacted your client back in an adequate period of time, or they contacted you back and you provided them with the opportunity to kind of pursue reasonable alternatives to cure performance. Again, reasonableness is all at play here with contract interpretation. So it is important for you to document as much as possible in writing. That's why notification is so important. And then kind of contract negotiations and reasonableness and alternative solutions to cure performance then comes into play for the remaining period of time. So then the parties usually have around 15 to 30 days to try and either cure performance, find an alternative solution, and if they can't come to a mutually agreeable solution, then the contract would terminate and move forward. Note here, you want to ensure that if termination occurs because you and your clients cannot come to an agreement and resolve the non-performance issue due to the force majeure event, you want to, again, have that sentence or two at the end of your clause explaining what happens to fees paid that I just talked about. I also really like notice requirements because it alerts your clients under the contract of what happens next. It just shows professionalism, that you care, that you understand they're affected or you've been affected, and here's what you're going to do. Rescheduling opportunities, alternative solutions to choose a different location to perform under the contract. Will there be any sort of partial refund issued, or will there be credits to their account? Answering all of their questions in written format when you're either invoking a clause or responding to a client invoking the clause. So it really should leave your clients feeling confident and comfortable with the fact that they know they have options and that you have thought about what happens next. So don't be afraid to issue multiple notices when it comes to a force majeure event. For legal purposes, again, the more evidential proof that you have that you've issued notice, the better. Not to mention, an unstable environment and unstable nature of a force majeure event means that things are always changing. So keep those lines of communication open with your clients when you're in a force majeure event and assure them that they can contact you about any concerns they may have, but be clear that they have X amount of days to make their decision on how to proceed and cure performance pursuant to the language in your force majeure clause. And I know I alluded to it previously, but one thing I found when I was doing a little bit more research on wildfires was an article that came up. I'll be sure to link it in the episode description, from an attorney who was dealing with a lot of contractual issues related to the Lahaina Maui wildfire. And I thought what was interesting is this particular attorney was saying, where did the 10 days notice requirement come from? It's just something that these hotel lawyers came up with. There's no magic 10 days. There's no magic 5 days. There's no magic 30 days. It's truly simply an attempt to cut things off. So one, the impacted party needs to tell the other party quickly of their decision. And I think what was missing here in this article, though, was the curing of performance. And yes, it's important to notify that you're invoking a force majeure clause as soon as possible, but it's equally as important to have a set period of time for you to cure performance, so that if you can't cure performance in that time, then this is the next course of action here. And this article was interesting because it just says, imagine being these hotels in the wake of this massive natural disaster in Maui. There's so many hotel contracts at play, and even places that were unscathed by the Lahaina wildfire, they were still facing infrastructure issues related to wildfire damage and hosting the relief workers. So this attorney was saying, it wasn't possible at that period of time for a planner or a hotel to know whether holding that wedding or meeting there would be illegal, impossible, or impractical, say 3 months after the Lahaina fire. They just truly didn't know. But if you have these notice requirements in your contract, then what would have occurred here, and if these timings were all outlined appropriately and you had that language at the end of your force majeure clause, it would be really clear to hotels and planners, okay, if we can't cure performance and we have no idea 30 days out. So you're talking to whomever your client is under the contract at 5 days, 10 days, notifying them that it has been impacted. We aren't able to perform right now. We might be able to perform in 2 weeks. Hold tight. Then you're consistently providing additional notice to them, documentation and proof that you're, doing XYZ diligently, trying to figure this out. Then by 20, 25 days, if you're we're getting really close to 30 days, we're not able to perform and cure performance, we can't find an alternative solution, and the parties have probably at that point tried to negotiate as much as possible, if they don't come to a mutual resolution, because you can always go above and beyond the bounds of your contract in an addendum or an amendment to the contract, right? Or a cancellation agreement, termination agreement to the contract. But if you can't come to that resolution, then say within 30 to 60 days, if that was your cutoff time, then what happens to fees paid? The contract would then tell you. So then it would be terminated. The hotel or the planner could terminate at that point, keep all fees paid, and move it to 6 months out, 12 months out, find an alternative solution, so on and so forth. So that's a really good transition here. Is a wildfire a force majeure event? Can your client try and cancel or reschedule or claim force majeure when wildfires are really running rampant in your region? The short answer is likely no. The long answer is it depends. Let me explain a little bit here. I'm not going to go ad nauseum at length as an attorney, but the Lahaina fire is a really good example of, yes, force majeure event, unforeseeable, unpredictable, impossible to perform basically throughout the entire island due to infrastructure and relief issues that were needing to occur. That scale of a natural disaster would absolutely invoke a force majeure clause. But in order to claim a force majeure event and deem the event a true force majeure event, please remember it would need to be unforeseeable, unpredictable, and impossible to perform. The word impossible and impossibility is so important here that you have in your force majeure clause. So for all of us that are in the northwestern part of the United States or in Canada or in places thick with trees and very much have wildfire season, if a wildfire swept through your specific venue that all of the providers and vendors were supposed to host this event at, and now it's burnt to the ground, then yes, force majeure applies. Or if the area is closed down completely, say you're an adventure elopement photographer here, if that area is unable to be performed at and to host the event, host the elopement, then you could claim force majeure. The crux of the legal ability to truly claim force majeure is if it is 100% impossible to perform. Now, I've talked about, okay, if the actual location is 1000% closed down due to you can't have your elopement there because a wildfire is sweeping across and then, the Forest Service like completely shut it down, or, the national park completely shut down. This is why I'm like, I don't love to have very, very specific locations as an elopement photographer in my contract. I like to have a region or a vicinity in your contract and not the actual location. So you would say a location, within a 30-mile radius of X location. And that way, if you have wildfires that are impacting maybe the, plan A location for the elopement, you still have plan B and plan C, and you're working through that with your clients. Always make sure that you have alternative plan options, and your contract allows you to then choose an alternate place to perform so that it's not impossible for you to perform. It's impossible for you to perform at that specific location, but not impossible for you to perform in that vicinity or region. Hopefully you're catching on here. Various ways that you can nuance language in your contract to better suit the services you're providing to your clients. Traditional wedding venues and weddings are a bit different because you really just have one location and it's whether you cannot perform at that specific location. So a good example of a true force majeure event, besides kind of the Lahaina fires and, a typical hurricane or avalanche just like decimating your venue or location, is one that actually happened in my hometown with a massive windstorm just a couple of weeks ago. No one could have predicted that we were going to get 110 mile per hour winds that were clocked in Missoula, Montana. It was like a mini hurricane is what people are likening it to. I was in the middle of it, and I actually live in a location in Missoula, kind of near the university. So think, big old trees, but lots of trees, and deep roots, but older trees, right? So Lots of branches and just trees galore and houses really close together and power lines intertwined with all of those trees. Our specific area and then other areas in town that had, lots of spruce and pine trees, those were the ones that were impacted the most. And this storm swept through on a Wednesday evening, late at night, like 8 p.m. to 9 p.m. And it was a true disaster. I was scared that trees were going to fall on my house. My kids were sleeping. I had someone over. They were calling their family and making sure they were okay. Our power went out immediately, did not come back on for multiple days. And here is what ultimately occurred is the entire city had power outages and power outages that they couldn't resolve quickly. They had to bring linemen and crews in from other states, and they had like 20 to 30 to 50 crews, I think 20 to 30, I think I'm exaggerating here a little bit, working at all times, 24/7, starting on Wednesday evening after the storm had stopped because power was out everywhere. And power was out for almost the whole weekend. I think some people were just starting to get some people got power back right away and they were able to fix those, but they couldn't fix all of them within, 24 hours. So people were without power Thursday, Friday, Saturday, Sunday. A lot of power started coming back on by Sunday and Monday of, like 4 or 5 days after. And I think they were back to like 95% of the city had power within 5 days. And yeah, so imagine if you are having your wedding or event after that force majeure event is absolutely claim force majeure all day long, unforeseeable, unpredictable, impossible to perform because there's no power now. Not that like it was completely wiped out, but if your venue was wiped out and you had trees down everywhere and you didn't have power, boom, force majeure event. And then it's all about like, how are you curing performance? What are you doing? I mean, if it's an actual wedding venue and all of the vendors are supposed to perform on that day, oh, nightmare of a situation. I think a lot of those venues had massive generators and backups. Luckily, this windstorm happened on a Wednesday. If it would have happened on a Friday or a Saturday, there would have been so many more weddings and events affected here in the, Western Montana, Missoula, Montana region. And I was like on pins and needles for some people. And I saw some photographers posting and venues posting on what they were doing. It was fascinating to see what was happening with like gyms in town sending out just constant notifications to their members because I think members, like some people were like, are we going to get prorated? Things were happening with our daycare as well. They didn't have power. And then parents were like, well, this is, uncontrollable for everyone involved. Do we get prorated? But you still have to like pay your employees and pay all of your bills and lots of notifications happening with business owners. It was truly fascinating to watch. What was not fun was the actual windstorm, but this is just an example of something that was a massive natural disaster that affected our entire city. And I was like, this is a true force majeure event. A wildfire that's occurring, in this similar location. The air quality is bad, but it's not like emergency shutdown of that entire region. It's foreseeable. It's predictable. You're in a region with wildfires. Hopefully the venue isn't burnt down and hopefully you can perform in some capacity. Bad air quality is bad air quality, but you as a service provider and your clients are signing up for that in that region. If you're in Montana, Washington, Oregon, Idaho, California, and other places that are now also being affected by wildfires in the United States, and obviously if you're in Canada as well, like you're kind of signing up for that risk. There's an assumption of risk occurring here for the foreseeability, the predictability of a wildfire potentially impacting your wedding and event and air quality and elopement, say, in July and August, and probably September as well, and maybe June. And your clients can't claim force majeure. You can't claim force majeure either. you're signing up for that risk as well. It's all about the impossibility to perform and alternative ways to cure performance. So hopefully, with all of that education and knowledge in mind, you can now more accurately respond to clients who are trying to invoke a force majeure clause, but it's not quite a force majeure event. Maybe this is an inclement weather situation that would allow for another location to be chosen or for a reschedule to occur. Maybe your clients want to move their elopement date, say, from July because just wildfires are like decimating the air quality and now you don't have like any mountains in the background. Maybe it would be appropriate that time to, this is inclement weather situation, and probably a mutual rescheduling negotiation where you would move it to, say, more of the fall for hopefulness of better air quality. But sometimes it just is what it is. And for more traditional weddings and events that occur on a certain date that's planned 12, 18, 24 months out, or, even shorter periods of time, some people choose, events and weddings 4-6 months out. But there's so many vendors involved. There's so many things involved. Like the venue in particular has very, very, very strict rules on force majeure clauses and invoking those clauses. And you should too, as a service provider. The last thing that I wanted to bring up, though, is who bears the risk if there is no force majeure clause in your contract. So without a force majeure clause in place, honestly, the risk typically falls on the shoulders of you as the service provider who has to somehow cure performance caused by this natural catastrophe, natural disaster, or, man-made disaster or man-made force majeure event. So since force majeure events are generally considered quote unquote acts of God, just remember that both the business owner and the client do share the risk, but you're the one as the service provider that's being paid, and it's up to you to try and cure performance if at all possible. So both parties are really, without a force majeure clause, left to the mercy of common law doctrines here of impracticability and frustration of purpose. Those are, contract interpretation defenses and common law doctrines. Those laws vary per state, as does the case precedent associated with them. So my suggestion is don't ever in contractual language, leave yourself open to common law doctrines and default rules. Try to protect yourself and get clauses in place that allow you to go above and beyond and for the parties to agree to, this is the business practices, policies, and this is kind of our course of action moving forward when a force majeure event does occur. So try to leave yourself out of having to deal with impracticability and frustration of purpose interpretations under your contract performance. Ultimately, I think you're just left with refund situations, termination situations that you as a service provider do not want to be in. And of course, always seek counsel of an experienced small business attorney to ensure that you as a service provider are exercising your right to a time extension through the doctrine of force majeure, if at all possible. As I wrap up here, are wildfires force majeure? Likely no. In very, very small instances, yes. Force majeure clauses, though, require a lot of consideration. You need notice requirements in them. They may seem like an afterthought, but I really want you to understand that notice is a critical component of a rock-solid force majeure clause. And you need to expressly delineate what force majeure events are and then what happens to fees paid if you cannot cure performance within a certain period of time under the notice requirement, and how your clients can be left with kind of a concrete solution for rescheduling credit of their fees paid so they don't lose out, but it's a transfer situation. If you still don't have a force majeure clause in your contract, or you have a non-Legal Paige contract, I want you to get one. Remember, I have perfected to my utmost ability this force majeure clause. I have looked at it. I have touched it many, many times. I have updated it with myself, my legal team. I have been on force majeure panels. I feel like I am kind of a force majeure expert. And I have a clause for you. I have an a la carte clause. You can purchase it. Boom, copy and paste, put it into your existing contract, and you'll be good to go. And with all of this education and knowledge that I've given you here today in this episode, you will also be way better equipped to deal with these types of situations if they were to come up with your clients, and know why that clause is in there, how to respond to clients effectively regarding that clause. Can they actually claim force majeure? Is it not force majeure? So I will link that a la carte force majeure clause in the episode description for you. If you have any additional questions about force majeure, or is this situation force majeure, we get these questions all the time in the Legal Paige community on Facebook. I urge you to join. It is a great community of thousands of entrepreneurs. And if you have a question that came up with a client regarding force majeure in your specific area and region, I bet there are others in there that also probably have similar questions, or they're nervous that those are going to pop up with clients. So it would be great. It would be great for you to post, great for me to respond. And my legal team, we monitor that group, and great for other entrepreneurs to respond as well, for you to kind of glean some insight from them as experts in the industry on what they have done or are looking to do in a situation like that. So I hope you enjoyed this episode. I am looking forward to talking to you in the next one, and have a wonderful week.